Hey, this is Derek Cafe with Cafe Realty. I wanted to talk today about a new law that took effect on July 1st, 2024 in the state of Georgia, HB 404, also known as the Safe at Home Act. This law just took effect in July 1st, 2024. And so, who does this impact? If you're a real estate investor who is a buy and hold or landlord, this is primarily going to affect, landlords. So if you're a wholesaler or you're a fix and flipper, for the most part, this isn't something that's going to affect you. But if you're a landlord, it definitely is going to have some impact depending on how you were operated and previously on your operations. So I'm going to say 3 to 4 aspects of it, 3 that we're going to talk about this House Bill 404, otherwise known as the Safe at Home Act. So, number 1 is, for the first time, Georgia has actually put a mandate on the fact that if you're renting out a property, it must be fit for human habitation. Now, I know for some investors or some landlords, you're like, okay, yeah, that's kind of what we've been doing, such as myself. But they put this here for a reason. There's some landlords who, kind of doing foul things. So basically your property needs to be fit for human habitation. Also, they made it where they added cooling to a list of utilities that cannot be cut off prior to an eviction. So apparently some landlords, I would assume it's more so if you're a landlord who pays for utilities. In my properties, I try to make sure that all utilities are in the tenant's name, and if not, primarily it's typically going to be water that's in your name. But you cannot cut off utilities prior to an eviction, or in general, you probably shouldn't cut off utilities at all. So that's one thing. Number 2, notice. So this is in the process of an eviction. Basically, you need to give the tenant 3 days notice prior to filing the eviction. So 2 aspects to this. One is you need to give a tenant notice in whichever way is written out in your lease. So if it says, if you say any communication is going to come through email, text, or mail, however you put it, you would still need to give notice in that way, but you also need to provide a sealed envelope with notice of, basically you're providing the tenant with a notice to pay the rent that's due or to vacate. And so basically from the times the rent's due, you're giving them 3 days notice prior to filing that eviction. Say on the 1st the rent's due, they don't pay on the 1st. On the 2nd, you can provide a note to pay or vacate the property, but you also must provide a sealed envelope with this same notice that is provided conspicuously. That means we're going to be clearly visible on a door. I'd say the front door. You want to put it in a place where it is obvious that there is a letter or a note for somebody to see. So primarily you want to hit it on the front door. And I'm not an attorney. My wife is an attorney, so you could potentially call my wife if you were looking for legal advice. But this is just my thoughts on the new law. And so with that, you would, if it's a side entrance, maybe place it on the side entrance, but you want to place it in a prominent location where they're absolutely going to see it, and in a sealed envelope. And so you must provide both of those notices. So if in your lease it gives a method of communication, you have to do that. And then also you have to provide the sealed envelope on a clearly visible door of the property. And so both of those things have to happen. Now, say the rent was due on the 1st, you sent out both notices on the 2nd day of the month. You have to wait the 2nd, 3rd, the 4th, and on the 5th, you could file an eviction. So that was number 2. Now, with regards to number 3, what they did was added a maximum, and that maximum is 2 months rent. Now, there still is no minimum. So if you were a landlord who didn't or require a security deposit, then this means nothing to you, but your maximum is limited to 2 months rent. So if the rent's $1,000 a month, then you can charge the security deposit up to $2,000, which will be 2 times the rent. So that is the nitty gritty of Safe at Home Act, which, like I said, went into effect on July 1st. If you want more information, feel free to reach out. It's not too major, but with this, as landlords and myself, a real estate broker and property manager, these are things that you want to stay abreast of, because this affects your bottom line. And so you always want to make sure that any litigation that's come up, I think many landlords kind of treat it like it's some landlords, I'll say, I'm not going to say many, I'll say some treat it like it's a hobby, but this is your business. So when legislation is coming up, you need to kind of stay aware of this, and you can find out through trade organizations, in some cases real estate investor organizations, or other groups regarding landlords and rental property, etc. So stay in touch, and that's it for me for now. But you should absolutely be aware of the Safe at Home Act, otherwise known as House Bill 404, which went into effect on July 1st, 2024, meaning that any leases or renewals that happen after July 1st these rules will apply to. So if you've been a landlord for the past 10 years, it's not backdated. It's not, oh, you were supposed to do this back in the day. No, from July 1st on, this applies. Now, if you have any renewals coming up, you have any new leases that are being written, this should apply to that. And so, that's it. If you got any other questions, reach out to me. My name's Derek Cafe. I am the managing broker and owner of Cafe Realty, also Cold Black Properties, its parent company. Look forward to speaking with you soon.